Washington state has some of the most detailed rent increase regulations in the country, and they've become significantly more restrictive in recent years. If you manage rental property in Washington, staying current on these rules is essential, because the notice requirements alone can trip up landlords who are operating based on rules they learned years ago. The governing law is found in the Residential Landlord-Tenant Act, RCW Chapter 59.18, and recent legislative sessions have added substantial new requirements that fundamentally changed how rent increases work in Washington. Let's start with the most important thing. Washington does not have traditional statewide rent control that caps the dollar amount or percentage of a rent increase. A landlord can technically raise the rent by any amount. However, what Washington does regulate, very aggressively, is the process, the notice period, and the circumstances under which increases can be implemented. The biggest change in recent years is the notice period. Washington now requires landlords to provide at least 180 days written notice before a rent increase takes effect. That's 6 full months, one of the longest rent increase notice periods in the entire country. This requirement applies to all residential tenancies, whether month-to-month or at the renewal of a fixed-term lease. This 180-day notice requirement was a dramatic increase from the previous 60-day requirement, and it fundamentally changed how Washington landlords must plan their rent increase strategies. If you want a rent increase to take effect on January 1st, you need to deliver written notice no later than the previous July. That level of advance planning is unusual and requires landlords to think about pricing decisions much further ahead than in most states. The notice must be in writing and must clearly state the amount of the current rent, the amount of the new rent, the percentage of the increase, and the date the increase takes effect. The notice must also include information about resources available to the tenant, including contact information for local tenant assistance programs. Failure to include the required information can invalidate the notice. Washington also requires the notice to be served by one of the authorized methods: personal delivery, leaving a copy with someone of suitable age at the tenant's residence and mailing a copy, or sending by both regular and certified mail. Proper service is critical because Washington courts scrutinize rent increase notices carefully. For fixed-term leases, the rent is locked in for the duration of the lease term, unless the lease includes a provision allowing mid-term increases. At renewal, the landlord must provide the 180-day notice of any rent increase, which means the landlord needs to communicate the new rent amount 6 months before the renewal date. This can create logistical challenges, particularly for one-year leases, where the landlord must decide on the renewal rent only 6 months into the current term. Now, here's where Washington gets even more complex. Individual cities have enacted their own additional restrictions on top of the state requirements. Seattle has been at the forefront of rent increase regulation in Washington. The city has enacted ordinances requiring additional notice provisions and has implemented tenant relocation assistance requirements for certain significant rent increases. Under Seattle's ordinance, if a rent increase exceeds a certain threshold, typically 10% within a 12-month period, the landlord may be required to pay relocation assistance to the tenant. The relocation assistance amount can be substantial, potentially equivalent to several months' rent depending on the circumstances. This effectively creates a financial disincentive for large rent increases in Seattle, even though there's no formal cap on the amount. Tacoma, Olympia, Burien, and several other Washington cities have enacted their own local tenant protection ordinances that may include additional rent increase requirements beyond what state law mandates. Some of these local ordinances restrict the frequency of increases, require additional disclosures, or impose their own relocation assistance requirements. Landlords need to check the specific ordinances in every city where they own property. Washington's just cause eviction law also affects rent increases indirectly. Because landlords cannot terminate a month-to-month tenancy without a qualifying just cause reason once the tenant has been in the unit for 12 months or more, a landlord cannot use a massive rent increase as a backdoor way to force a tenant out. If a landlord raises rent to an unreasonable level clearly intended to make the tenant leave, rather than reflecting a genuine market adjustment, the tenant could potentially challenge the increase as a constructive eviction or as a violation of the spirit of the just cause framework. While there's no specific statutory provision addressing this directly at the state level, Washington courts and regulatory bodies are increasingly attentive to rent increases that appear designed to circumvent just cause protections. Rent increases cannot be retaliatory. Washington has a strong anti-retaliation statute under RCW 59.18.240 that prohibits landlords from raising rent in retaliation for a tenant exercising any right under the Residential Landlord-Tenant Act. Protected activities include making a good faith complaint about habitability to a government agency, reporting code violations, exercising the right to repair and deduct, participating in a tenants organization, or asserting any other legal right. If a rent increase is implemented within 90 days of the tenant's protected activity, there is a rebuttable presumption of retaliation. The landlord must prove that the increase was planned for legitimate business reasons and was not motivated by the tenant's actions. The 90-day presumption period is important. It means that any rent increase notice served within 3 months of a tenant's complaint or protected activity carries an automatic presumption of retaliation. Landlords should be very careful about the timing of rent increases relative to any complaints or disputes with tenants. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and Washington's own law against discrimination, RCW Chapter 49.60, landlords cannot raise rent based on a tenant's race, color, national origin, religion, sex, sexual orientation, gender identity, disability, familial status, marital status, veteran or military status, or any other protected characteristic. Washington's anti-discrimination protections are broader than the Federal Fair Housing Act and provide additional categories of protection. Washington's law against discrimination is enforced by the Washington State Human Rights Commission, which investigates complaints and can take enforcement action, including ordering damages, civil penalties, and injunctive relief. A discriminatory rent increase can result in significant liability for the landlord. From a practical standpoint, Washington's rental market is one of the most dynamic in the country. The Seattle metro area, including Bellevue, Redmond, Tacoma, and surrounding communities, has experienced dramatic rent growth over the past decade, driven by the technology sector and population growth. Rents in the Seattle area are among the highest on the West Coast, and even with the 180-day notice requirement, landlords in the Seattle market have been able to implement significant annual increases due to strong demand. However, the combination of the extended notice period, potential relocation assistance requirements, and just cause eviction protections means that Washington landlords need to approach rent increases strategically. A large increase might generate more revenue per unit, but if it triggers relocation assistance obligations in Seattle or causes good tenants to leave, the net financial impact could be negative when factoring in vacancy costs and turnover expenses. Eastern Washington, including Spokane, the Tri-Cities, and smaller communities, has a different market dynamic. Rents are lower, demand is less intense, and the regulatory environment is generally simpler because most Eastern Washington cities haven't enacted the additional local ordinances that characterize the western side of the state. Landlords in Eastern Washington still must comply with the statewide 180-day notice requirement, but they're less likely to encounter the additional local layers that Seattle area landlords face. One best practice for Washington landlords: create a rent increase calendar that accounts for the 180-day notice requirement. For each unit, note the date you need to deliver the notice to have the increase take effect at the desired time. Build in a buffer of a few extra days to account for delivery time and potential service issues. Missing the notice deadline by even 1 day means the increase cannot take effect on your planned date, which can cost you a full month's revenue at the new rate. Another best practice: document the business justification for every rent increase. Keep records of comparable market rents, operating cost changes, property tax increases, insurance premium changes, and any capital improvements you've made. This documentation protects you against retaliation and discrimination claims and demonstrates that your increases are driven by legitimate business considerations. Washington also has specific rules about how rent increases interact with subsidized housing. For tenants receiving Section 8 or other housing assistance, the rent increase must be approved by the housing authority administering the subsidy. The housing authority will evaluate whether the proposed rent is reasonable for the market and may deny the increase if it exceeds the fair market rent for the area. Landlords who participate in subsidy programs need to coordinate rent increases with the relevant housing authority well in advance. For the complete guide to Washington rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our landlord-tenant law series.